A white-collar defense attorney mistakenly sent an email to me that he thought he was sending to our client, and it was interesting. I'm going to cover it in this video. Let me tell you what happened. So I'm in Los Angeles Friday and Saturday filming for a white-collar crime documentary, and on Saturday, in a separate project, I'm driving to Bel Air Country Club to walk 18 holes with my good buddy Chris Case, with whom I'm working on a project. I'm going to put up a photo. That's Al Michaels in the background, by the way. So I'm pulling into Bel Air, and this email comes in, and I had to pause for a moment and think, how is this going to go down? I'm going to tell you, by the way, welcome to the channel, by the way. I'm so grateful that you're here. It's a Sunday. I'm not going to post this till tomorrow because I'm going to do a little bit of editing, some images, some evidence for all of you. So I'm pulling in, I read this email, and the first point he thought he was saying to our client. Number one, this person, Mr. Paperny, he was aware of our work. This person, Mr. Paperny, was unable to keep himself out of federal prison. So if he was able to keep himself out of federal prison, how is he going to keep you out of federal prison? Think about that for a moment. I was sentenced in 2007, no experience in the criminal justice space other than living as a defendant for more than 3 years. Speak openly and honestly about my inability to mitigate, self-advocate, do more to convey to Judge Wilson why I'm worthy of leniency. Get sentenced to 18 months. But because apparently I was sentenced to federal prison in 2007, here in 2024, despite 14, 15 years of service, thousands of clients, thousands of sentencing hearings, a lot of lessons learned, I am incapable or not qualified to help our new client try to avoid prison because I went to prison in 2007. Okay, number one, that's number two. He then went on my YouTube, on the end of my email description, there's the video and podcast I did with Dr. Phil. And then he's like, that ridiculous BS nonsense video with Dr. Phil and Paperny is total propaganda, total and complete nonsense. And it's like, well, which part? And then he said which part. Specifically, our client had sent him this 5-minute video. By the way, I'm wearing the same shirt I did in the YouTube video last Sunday. Don't judge me. I do have more clothes. What happened was, in a prior email, our client had sent like a 5-minute snippet of my podcast interview with Dr. Phil, where it says like 4 things you need to do before sentencing in the probation interview. Write the narrative, convey to the judge why you're worthy of leniency. And apparently Dr. Phil in that clip said, it doesn't matter what the lawyer does. And that has been off-putting to people. I didn't say it. That was really off-putting to this lawyer. Like, it doesn't matter what the lawyer does. The defendant has to do all of the mitigation and advocacy. And look, I want you all to understand, like, we believe in the lawyer, of course, and what they do, but there's also the role of the defendant. You've got to be the superhero, people. You got to be the superstar of your own mitigation. You got to take control of your own life. You can't outsource that to a lawyer, a golfer, to stick with this. They hit the golf shots. The caddy may advise them. You're the one who's going to do the probation interview. You're the one who's going to speak to the judge. You're like, oh, I'm moving forward for effect. I'm stepping up. You're the one who's going to work with the case manager. You're the one who's going to deal with the halfway house bureaucrat. You're the one who's going to deal with the probation officer. So does it make sense that you learn how to advocate and do this work and express through your own efforts why you're worthy of leniency? We think so. For that reason, of course, your lawyer is essential, but ain't no one more essential than you. And I'm going to convey what I'm doing this in one breath. I'm going to convey what Judge Bulwer said at a conference last year. Here's the order of mitigation: defendants, lawyer, friends, and family. Then he said a lot of defendants gets that order backward. They outsource all of the work to lawyers, and they rely on friends and family. People like Elizabeth Holmes or Sam Bankman-Fried do that. They do not mitigate or take action. That is not the right approach for our firm. So he didn't like the Dr. Phil piece, specifically that 5-minute clip. He was not a fan, to put it lightly. Then he continued. He then went on to say, your judge will not be reading a 10-page letter that you want to produce with this team, nor will I be turning in a 10-page letter. Now, admittedly, we've heard that a lot over the years, that a sentencing narrative that's several thousand words, could approach 10 pages, is too long for a sentencing judge or probation officer to read. And my question is, like, was there evidence of that? Have you ever been told by a federal judge this is too long? Because we continue to get evidence, and the reason I'll post this tomorrow and not today is because I'm going to put up evidence from clients who have told us the narrative helped keep them out of jail, including comments from federal judges. Some of them were more than 10 pages, but it's very common for a lawyer to say it's too long if they don't believe in the defendant's ability to mitigate. And here, that was the disconnect with this lawyer, who admittedly called me in the afternoon on the way home, embarrassed, apologized, and we had a very good conversation. Like, he wasn't happy that he had sent it to me. But that's the disconnect. Some lawyers think they're the superstar. They're the hero because of the Ivy League degree, the money, the background, and damn, some of them are educated, smart, good litigators, good lawyers. I mean, the best. They get paid a lot of money for a reason, and I want you to have a great lawyer, but something they're the superstar and the hero. We view it differently. You are the hero. You are the superstar. For that reason, would you rather turn in a 10-page letter with the right message? Here, I'm going to walk forward again for effect. This is all part of my shtick right now. Would you rather have the good messaging in 10 pages, your life, authentic, plans moving forward, how you identify with victims, what you're memorializing today, tomorrow, and moving forward for more leniency, not just at sentencing, earlier release from prison, more liberty, unsupervised, really clear. 10 pages should become 100 pages, 200 pages. What's my experience? Started off with one blog from federal prison with Michael, grew to another blog. The blog was the harbinger for lessons from prison, ethics in motion. Now we have tens of thousands of pages started with one blog. We need you to start, and it could start with this narrative. Also, this is also off-putting to some lawyers, and I discussed this with the lawyer yesterday after he called to apologize. You're going to turn in, a 50-page memorandum? Fine. Can we agree that a lot of things in the memorandum are things the judges have seen repeatedly? Yes. Is the memorandum more authentic, more boutique, more strategic if it includes the own words of your client? He can acknowledge that it did, though he said, I'm just not used to a letter that's so long. I said, be objective. Be objective. I'm asking you, once our team produces it and you review it, to please be objective. And he said, I absolutely will. And I'm going to put up a screenshot from a message we received from a client lawyer, and the lawyer would not review the narrative. Our new client did it anyway, finally sends it to the lawyer, who about a week later responded and said, I read it, this is amazing, I'm going to put up a screenshot. I'm going to attend our client's sentencing hearing next month in San Diego. I'm going to do a YouTube video from there. There was a few other things he said in the email that they were kind of personal, and I'm not going to get into. Perhaps he was offering some opinions about my political persuasion, which I thought was unnecessary because I've never said which side of the aisle I err on. It didn't seem to make sense in my opinion. And there was a couple other things I found a little bit unprofessional. But look, we all make mistakes, and I'm grateful that he called to apologize. But regardless of how the call went, or regardless of whether he called to apologize or not, one thing I'm not going to do is cower or shy away from what our team believes, what we've learned from federal judges. You're the superstar. You're the hero. You've got to change the version of events. These people, let's own it. I'm going to walk forward again for effect, okay? They think you're trash. They think you're scum. They do. Some case managers don't like the First Step Act. They don't want to let you out earlier. Some judges don't like the First Step Act. They don't. They identify with victims. They don't like that on 37 months you could be home in 10 or 11 months. No bueno, no good. They no likey. They want you in jail longer. So if you don't embrace this, we think you're weaker. And if you buy in, the AAC's coming on behind me. These people don't know I'm working. If you embrace the idea that only your lawyer can mitigate and articulate why you're worthy of leniency, that's fine. It's not what our team believes, and it's not consistent with what we've learned from judges. If you believe that it can be done collaboratively, where your lawyer sells the stuff that you can't sell. You can't sell how you cooperated. You can't sell you paid all the money back, because it's self-aggrandizing that makes you look like a hero. It gets away from what only you can do. Deference, humility, lessons learned. Do it in a good cop, bad cop way. Do it in a way that's collaborating, working together. Those that do it, in our experience, they get better outcomes. Those that don't tend to call us and say, hey, I watched that video with Dr. Phil. I watched the video you did with the federal judges. I read that New York Times piece. Why didn't I get an outcome like Hugo Mejia or Stanley Benton? It's pretty clear you didn't mitigate or believe in self-advocacy or trying to change the narrative through your own efforts. You are all awesome. I'm so grateful that you're here on the White Collar Advice channel. I'm going to post this thing tomorrow, and I'm going to return soon. Goodbye.
What you've said is, if you know what you know, and it is that if they do their homework, and they will, that they've got you, then you're saying go in and cut the best deal you can as quick as you can, because the less sweat equity they have in this, the more likely they are to cut you a reasonable deal. Then you talk about something that I think people so underestimate the importance of, and that is the pre-sentence hearing statements that are made. And it doesn't make a damn what the lawyer says, but you talk about 4 elements of the pre-sentence hearing points. Will you go over those and talk about why it's so important that these things are covered when they go into the pre-sentence hearing?
So we have to understand that at the pre-sentencing hearing, the probation officer has the narrative that's been given to them by the government, namely your plea agreement that shows you broke the law. unless defendants begin to change that narrative, they're going to be judged by that plea agreement, by the government's version of events. So we coach defendants to articulate at a pre-sentence interview or in a narrative or statement they'll make or in a sentencing video 4 points. And the first is, it's not about you. It's not about how your life is imploding. You've got to identify with your victims. You've got to be able to say, as a result of my conduct, I created victims, I'm ashamed, and I'm embarrassed. I recognized I hurt people. It's always the focus on the victims. It is not my friends, family, my community, and the victims. The victims always comes first. So that's number one.
And who are the victims in this university scam? Are we talking about the university? Are we talking about those that didn't get preferential treatment?
I would argue that the victim is the student, perhaps working 2 or 3 jobs, studying as best they can, applying to schools, and their application was denied because someone who might not have earned it took their spot. They've got to identify and apologize to those victims. Number 2, properly demonstrate your remorse. If we understand the stakeholders, the judge, prosecutor, probation officer may think, oh, you're only saying sorry because you got caught. Certainly some people say I'm sorry only because they got caught.
Sure.
So rather than a lot of lip service or happy talk, they've got to begin to convey through their own efforts, not just the lawyer. We talk about that a great deal through our work. Lawyers are paid to extol the virtues of their clients. You look at the greatest criminals in our history, Dr. Phil, their lawyer said something, Charlie Manson, the lawyer probably said something about Charlie Manson positive at his sentencing. They're paid to do it.
Yeah.
And I hope these lawyers do it well. What we've learned is they've got to begin to articulate through their own efforts, their remorse, their contrition, and build this record over a sustained period of time. 3, they need to talk about what they've learned through this experience. They need to become introspective. They need to walk the government through the pressures they face, the rationalizations they gave into, and the opportunities they seized. If they can begin to show that awareness, they then can convey, I'm not going to be here again. I've learned my lesson, more than just saying, I'm sorry, don't send me to prison because I have children, which is what a lot of defendants do. And number 4, they do have to convey to the judge and a probation officer and prosecutor why they're never going to return to a courtroom. And if they can convey those 4 points in a pre-sentence interview, they're going to begin to equalize the narrative. The government should begin to look at them for more than some out of character decisions they have made, look at the totality of their life, because in this case, these are wonderful parents. These are wonderful people who have contributed and led lives of contribution for a long time. And we want others, through these 4 points, to see more of that rather than say nothing, which is what many of them do. And if you say nothing, what's the judge going to judge them by? The plea agreement and the government's version of events. These 4 points are the salient points we covered a pre-sentence interview, and it changes the game if done well and done authentically.
In my opinion, there is no doubt that these items actually change the likely sentence that you're going to get. I mean, if somebody hears these, it makes a difference.
We have had clients call us after a sentencing and say, by virtue of my efforts to convey to the judge that I'm sorry and remorseful and I identify with victims, the judge commented on it. It's in the transcripts. I can point to it. I got this sentence. The government asked for 3 years. I got 18 months. The government asked for 2 years. I got probation. I got 1 year of supervised release instead of 3. I'm so grateful. And what I tell defendants is, even if the government asks for 3 years, and even if you get 3 years, for the rest of your life, you will never live in regret. A lot of defendants live in regret, and they serve time in federal prison wondering, I wish I would have done more to prepare, but I didn't. It's nice not to have any additional regrets as we age and serve time in prison. And there's a sense of dignity and strength from knowing you did all you could to prepare. I spoke with Judge Benita Pearson on stage last year in a lawyer event, and she said to me, Justin, defendants should leave my courtroom exhausted because they've worked day and night to prepare for the best outcome.